Welcome to California in Focus. I'm Eliana Kernodle. California quietly doubled down on its termination of single-family zoning, ending loopholes that allowed municipalities to block an earlier state law designed to let owners build 4 homes on existing single-family lots. Joining me with more on this story is the Center Square's California reporter, Kenneth Schrupp. Kenneth, let's start with the background. What was Senate Bill 9 and how have cities blocked its implementation?
Hey, Eliana, there's a 2021 law called SB 9 in California that pretty much ended single-family zoning in the state. It was supposed to allow owners to split their single-family home lots into 2 lots if they'd never been split before, and then build 2 new homes on each lot. So you could buy a single-family home lot, split it in 2, and build a duplex. This is supposed to alleviate the state's major housing shortage. Housing construction has declined significantly over time in California, starting in the 1970s. And as a result, housing prices are quite high. However, not many homes were built under SB 9 because cities adopted a lot of regulations to make these projects no longer feasible. Temple City required that 1,000 square foot courtyards be built to create distance between SB 9 homes. And Redondo Beach won a lawsuit earlier this year when a judge said, this law can't apply to charter cities because it doesn't actually meet the purpose of providing affordable housing, because under SB 9, there's no requirement that the homes built be income restricted, quote unquote, affordable housing. Affordable is a definition used by the state that applies to different income groups depending on how affordable it's supposed to be. Moderate income, quote unquote, affordable housing is income restricted to people making between 80 and 120% of area median income, which means that it's often market rate housing. But that's besides the point. The judge ruled that you can't have these statewide ordinances take away a lot of local control because there wasn't sufficient grounds to do so. There wasn't enough of a compelling reason to take away this power.
So Senate Bill 450 was passed last fall and just went into effect with the new year. What is it and how does it respond to the roadblocks that faced SB 9?
Right. So it really takes away the power of local authorities to reject these lot splits and then the building of duplexes. It also redefines the state housing goals directly in response to charter cities' power over municipal affairs to get around this lawsuit. The California Constitution gives charter cities, the state has about 126 charter cities, so it's about a quarter of the state cities. They have enshrined massive power over their own municipal affairs. In the city of Huntington Beach, for example, this municipal affairs power was cited by a judge who upheld the city's local voter ID law. So the state pretty much has ruled in court that cities have a lot of local power, and that SB 9 took away a lot of that local power. SB 450, it goes ahead and requires local governments to approve or deny these projects within 60 days. It removes or reduces demolition restrictions, environmental and design reviews, and requires that denials come with a list of problems with the application and how to fix them. It also creates this shot clock where projects that aren't denied within 60 days are automatically approved. There are a few limitations that were put in, but it doesn't really seem that they'll have a huge effect. The law only applies to census-defined urban areas, which is pretty much a non-limiting factor because 94.2% of Californians live in census-defined urban areas. It also requires that the resulting lots from these splits be at least 1,200 square feet and no less than 40% of the size of the original lot. So lots have to be at least 3,000 square feet to be split. But this also isn't really a limiting factor because the average lot, even in San Francisco, which has the second smallest average lots in the entire country of any major city, they're at about 6,084 square feet, about twice as big as the minimum required to do the split. So pretty much every lot is probably eligible for the split. The League of California Cities, which includes pretty much every city, including a lot of charter cities, have said that there's just too much work to be done to keep up with the state's new housing laws. and that they just don't have the capacity to meet existing laws that continue to come through the state and to meet laws like this.
Well, Kenneth, thank you for your insights on this story. Listeners can keep up with this story and more at thecentersquare.com.